Good morning.
Good morning.
Yes, please call out the letter.
Good morning. IEBC represented by Kinyao Advocate, Jubilee represented by Omwoyo Advocate, then election appeal number 3 of 2023. IEBC, the appellant represented by Kinyao Advocate versus Michelle Kemuma Omwoyo, represented by Omwoyo Advocate, Dolphine Nyangara represented by Ochoki Advocate, Jubilee Party represented by Omwoyo Advocate. Both coming up for highlighting of submissions. Welcome.
Yes, can I take the forum very fast?
My lady, with your permission and the permission of my colleagues, allow me to do the quorum.
Yes.
My name is Sam Leveli.
Yes.
I appear alongside Mr. Dunstan Omari,
President, good morning, my lady.
Ms. Dorcas Moy,
President, I know. My lady, sorry.
Her name again?
Dorcas Moy, WAP,
Yes.
and Lisa Wairimu,
I'm President.
Lisa.
Ms. Wairimu,
Yes.
for the first respondent, that is Michelle Omwoyo, who is the applicant in the application that I'm bringing for you today.
Yes.
Mr. Ochoki
Yes.
is present, appearing for the appellant in election petition number 1 of 22 and 1 of 23.
Yes.
Mr. Masharia,
I'm present. Good morning.
Yes.
Mr. Masharia is present,
Yes.
as always brief for Mr. Shadrach Omwoyo, who I believe should be joining online, much as I'm not seeing the gadgets, for the IEBC.
My union presence. Mr. Mashari.
And Mr.
Just a minute.
Sorry, sorry.
So Mr. Shadrach will be more present.
No, Shadrach Omwoyo will be joining us. We said we have indicated that we do a
Mr. Council will
hybrid.
say this.
That is Mashari, or Mashari is present. He's holding his breath. He'll be holding his breath.
Oh, Mr. I thought you said Mr. President, so I got you Mr. Shadrach. For which party? Shadrach
For IEBC.
Yes. Yes.
And Mr. Omwoyo, Wycliffe,
Mr.
is Omwoyo, Omwoyo, Omwoyo,
O-M?
AYIO, Omwoyo,
Yes.
for the Jubilee Party. That is the third respondent.
Yes.
Already, perhaps we do some housekeeping. My techies will do some housekeeping in
Yes.
terms of the timings that we're going to be engaging.
Before we go to the timings, let me know what we are doing.
Yes.
I just saw this, some of these documents a few minutes ago. And when councils appeared online, we said that you should send me that first copies. And you were given our email address. So I never got those copies. In fact, I had to be here very early yesterday so that I could read the submissions. Because I saw them only yesterday. The reprise, I've just seen the donor was coming into this place. Since I came in the morning, I need this. So can I know who has filed what before we go to other issues? I want to know that I have everything on record before we go to other issues. And I know some of the documents were even filed in the morning. Submissions for the IEBC. Isn't it? Changes of residence councils, isn't it? Now, when we keep running like this, and we don't have so much time. So when we give timelines, please, let us confirm the timelines. Now, we are dealing with the application dated 14th
14th March.
14th of March.
Yes.
saw a reply that you have only appearance.
My lady, I believe that is the appellant's applying affidavit.
Yes, can you confirm for me what has been filed, what has not been filed, so that I know I have all the documents on record before we can start taking a lot of advocates. What
Of the IEBC replying
yes,
affidavits.
and one of you confirmed that these documents are there. So what responses have been filed, replying affidavits filed on?
For the appellant, my lady, there is a replying affidavit filed on 28th of March, 2023.
Sworn by?
Sworn by Dolphine Nyangara.
You have that affidavit?
Yes.
Yes.
I'm also aware, my lady, that the IBC had filed a replying affidavit sworn by one Crispin Owiye. I passed on my copy to the courts.
Was it filed?
29th March.
We have it.
Yes.
Yes.
Yes, those are the responses. Mr. Omwoyo can confirm because it indicated is not opposed to the
Yes, I
application.
put that on record.
So those are the two replies in opposition to the application.
Perhaps
Yes.
my lady, so
Yes.
that he finishes that, you should
Yes.
also confirm perhaps maybe he has filed the submissions so that we don't.
Yes, we know your passport the submissions because these ones I've not even seen them. Because when I asked for them when I came in the morning, they had to be traced.
My lady, the
So I
appellant,
just wanted to know that we have the correct documents before we go to the submissions, the responses. So those are the only two responses that we have.
I believe so. I don't know whether.
My lady, on our part, we did not file a reply affidavit.
Yes.
Instead, we went straight to filing some written submissions.
Are you opposing or you are?
We had indicated that we were supporting the application,
Yes.
such that the written submissions we put in
Yes.
what advance what was sought
Yes.
in the application because it suits us and that's our plans.
Yes, this is Mr.
Mr. Omwoyo for the third respondent, Jubilee Party.
Yes. So I'll put that on record. Then can we now go to the submissions? We have 3 sets of submissions, isn't it? The submissions by all the parties.
Yes.
Just to be sure,
Yes,
the
yes, let's.
appellant had filed an application actually. Initially, we filed submissions in respect of the petition, and on 12th of April,
Yes.
we filed submissions in opposition to the application dated 14th of March, so that there is no confusion.
Okay, let us first deal with the application.
Yes, so that I wish
Yes.
that there is no confusion, because I notice the submissions being referred to are the ones for the substantive petition.
No, my issue is, what is coming up for hearing today is the application. So the housekeeping is in respect to that application.
It's okay. They are the right submissions.
Okay, so the applicant in respect to the application has filed.
The respondent, the appellant.
So this, okay, let me start with the applicant. The applicant to that application filed their submissions.
re-elected to 29th of March 2023.
Filed on?
31st.
31st of March. Just confirm, I have seen that, I have gone to the list of, just confirm that I have.
For submissions, the list of auditors.
Yeah, final display is, we were filed on 12th of April.
Sorry?
12th of April.
We are looking for submissions to the application. I know there are submissions to the petition. We are first dealing with the application.
Yes, okay, they were received on 12th of April, but we filed on the e-portal on the 31st of March.
That is for the applicant?
Yes,
The application?
yes.
The list of authorities? We have the list of authorities. Okay. The first respondent? The respondents to that application?
My lady appellant, I believe is the first respondent.
Yes.
We filed our submissions.
When were they filed?
They were filed on 12th of April 2023. They are bound.
Do you have that? Any list of authorities?
Yeah, we've annexed it to the accounts of ours.
Yes.
There is. Yes,
Yes,
there
yes.
is a list of authorities.
Okay. I
Yes, my lady, our submissions are dated 6th of April.
when were they filed? Today. What's the number
We
today?
we initially filed online. I believe they had not been stamped, but I believe they are now stamped.
No, but they are the ones that are filed in the morning. Any list of authorities?
The list of authorities, it's enclosed for the same. It's one time.
Yes.
Both are dated the same date, 6th of April.
The other respondent?
My lady,
Yes.
we filed our submissions dated the 10th of April,
What were they filed?
on the 12th of April. I have a note that
Sorry?
in my stamp that they were received on the 31st of March.
Okay, give it here. List of authorities?
We do have a list of
So can I now, can we now effectively say that we have all the application and the responses and the submissions? Yes. Now, we say, council. Now, council for the applicants. How much time are we looking at for highlighting? I've read the submissions, only the one for the ABC that I've not read. Because they were filed late this morning. But I've read the other submissions. So council for the applicant, how much time are we looking
My
at?
lady, we've segmented ourselves because we are many, and
Yes.
we have thematic areas that we want to address the court on.
Okay, how many are addressing the course?
Actually, all of us are addressing the court.
We don't only address the court, address the submissions.
My lady, we took thematic areas of concern that we're going to address the court on, and each has a role to play. And that is what we're saying.
Yes,
If we can be given time,
yes.
then we compress ourselves within that time frame, so that we can bring out what we want to present it to it.
Or all the four of you will address the court.
All the four of us are going to address the court without repeating each other. And I don't know whether 45 minutes or 1 hour.
For all of you.
Yes. It's the maximum 1 hour.
I'll give you 45 minutes. If the submissions are there.
Yeah. We just want to pinpoint some aspects to the court. Yes.
So 45 minutes will be that.
We would have been glad with 1 hour. Like, so that each is 20, 20, 15, 15 rather. 15, yeah. We may, let's just put it as a maximum of 1 hour. Then we can even take it for 45.
Okay, counsel for the first response.
My lady, I thought I'd only rely on my submissions, but now that my colleagues are taking an hour, I'll also ask for an equal amount of time, because I'm not sure how long they will take. Because ordinarily, we compress it.
Ideally, I don't
Yes.
take all submissions. I mean, all highlights. Because when you give me the submissions, I read them.
That's my take.
But this being an elected petition, I want to give you some time. But at the same time, don't take so much time. Because I already have submissions.
But that's my take. But now, my lady, if my colleagues are going to take 1 hour, I'm going to be asked, why are you taking less or more?
Who will ask you?
I am answerable to my client. I'm instructing the client.
No, you are an officer of the court.
Yes.
And there is only
Let me see how
prudent use of judicial time.
Let me see how it goes.
Yes.
But having had you, my lady, I think 30 minutes will be sufficient based on whatever issues they'll raise.
30 minutes. Counsel for the second respondent.
My lady, for us, I believe we have filed comprehensive submissions.
Yes.
But we will just take 15 minutes. Just highlight some features in our submissions. I believe they are comprehensive enough. It should not be the reason why we filed late. We obviously apologize. 15 minutes.
Okay, 15 minutes.
Yes, ma'am.
Okay, that respondent.
Line Mr. Checkers, my hands will be on my neck. Their position being advanced.
We are officers of the court, so you don't have to override what your cards you say. At the end of the day, it's not the amount of time, it's the substance.
True.
Yes,
My
that
lady,
is the point. So counsel, you asked me how much time?
At most 10 minutes.
10 minutes.
My lady, Mr. Omwoyo submits
Yes.
that he's supporting the application.
Yes.
I don't know whether he can be lumped with the applicants so that he does not submit after us.
Yes.
And then we start saying that he's raised an issue that we may need to respond to.
Yes, you will be done together so that
Thank
you now cancel for the respondents, the ones who are posting the application and submit after they are submitted. Then the applicants will have a right to speak. How much time?
Maybe.
I don't want to say it depends. Time is fixed on stone there. So
We have a maximum of 15.
Sorry?
A maximum of 15, madam.
A maximum of 15 minutes. Okay. So the applicants, I'll give you, I don't want to say that the report is unfair. I'll give you your 1 hour, how you are going to divide it out. Is it 15 minutes each, or how you are going to divide it out? After 1 hour, we will not have to extend. So first, counsel for the first respondent, 30 minutes, second respondent, 15 minutes, third respondent, 10 minutes. Then applicants, right of reply, 15 minutes. And who will keep for us time? Sorry? One of you can keep time. Time is okay. Yes. So that we are able to manage, because if we leave it, especially where there are 4 councils, you can go on and on and on. So towards the tail end, we find that one of you has not submitted. So for purposes of timekeeping, each of you is asking for how much time? So
We can even
once
take
your
less.
few minutes
Yes,
are
yes.
through, you are stopped.
About 15.
15 minutes. So Florence, please keep us for us time, 15 minutes each for the councils for the applicants. Council for the first respondent 30 minutes, first respondent 30 minutes, second 15 minutes, and third 10 minutes. But that council for the third respondent will submit immediately after the council for the third applicant have submitted. Yes. So now, can I say now your 1 hour starting?
Yes, this is 1:30.
Yes.
So perhaps I don't have that. Already, what is before you
Yes.
is the notice of motion application dated 14th of March 2023. It is supported
Yes.
It is supported by the affidavit of the applicant, that is Omwoyo, and the major prayer that has been sought is to strike out appeal numbers 1 of 2022, number 1 of 2023, and number 3 of 2023. Allow me to call them appeal number 1, 2, and 3 in that order. Appeal number 1 of 2022 Appeal number 1 of 2022 and 1 of 2023 are by one Dolphine Nyangara cover. And appeal number 3 of 2023 is by the IEBC. The first appeal is against a decision that was made on the 25th of November last year. Made on the 25th of November 2022. Appeal number 2 and 3 are against the judgment. That is when I call them up, number 2 and 3 is against the judgment which was entered on the 11th of January 2023. Both. Now, for the first appeal, the only document that is in the file is a memorandum of appeal. The second and the third appeal are against a judgment of the court. That is the magistrate's court, the first trial court.
Yes, call it the trial court.
Yes. Now, these appeals are governed by the election, parliamentary and county petition rules 2017, among other regulations.
They are governed by?
The elections, parliamentary and county petition rules of 2017, among other legislations. And I am invited, sorry, fast because I want to leave my time, but it's okay, I'll continue.
Yeah, I just want to think.
Now, the rules that govern the same are contained in rule number 35, sub-rule 6 of that election parliamentary competition rules.
35?
35 sub rule 6.
Yes.
Now, it gives out what should be contained should a party prefer an appeal. And the content of what have to go in on appeal is a mandatory requirement, because the underlining word on that 35 sub rule 6 is shall. Shall. Now,
Just a minute. Yes.
do appeal number 1, 2, and 3 have a memorandum of appeal? Yes.
Yes.
Do they have a record of appeal? All of them? No.
Yes.
Because the record ought to have been filed within 21 days of the date of the decision that has been appealed against. Appeal 1, its record ought to have been filed by the 23rd of December, the year of our Lord 2022. By the 23rd of December 2022. We do not have a record as yet, and as the time of filing these submissions, we have over 97 days, and we are still counting. Actually 98, and we are still counting. Today, we are still counting. And the appellants have not sought to remedy that filing or seek leave even to file a record of appeal. The second and third appeal
Just a minute. Yes.
The second appeal, with judgment was on 1st of February, 1st of February this year.
Mr. President, yes.
1st February this year, had its record filed on the 7th of March this year. And the computation of days was 34 days outside the legally provided for period. The third appeal had its record filed outside the legally mandated period, outside by 10 days. Because it was filed on the 24th of February this year.
Who's it was filed
On 24th of February this year. 10 days outside the period.
How many days?
10 days outside the legally provided period.
Yes.
Now, was there leave sought by the respective appellants to then purport to file their appeals or the record of appeal to make this court have locus to even hear them? A simple answer to that is a big no. We say so on the following reasons. In the entirety of the proceedings, we do not seem to have a letter seeking for supply of those documents from the trial court. We don't seem also to have evidence by way of a receipt from the trial court. We equally do not have a certificate of delay from the trial court. So when we do not have these three items, why are we here? Is there an appeal before you? And the answer to that is still a big no. On the 28th of February this year, there was an appearance made in this matter before your sister, where there was consolidation of the three appeals. Apart from consolidating, there was no any leave granted by either of the respondents, that is the petitioner and the IEDC, to file their record of appeal. I invite the court to the proceedings of that date, the 28th of February this year, and I'll be vindicated that that is the true and accurate position of proceedings on that date. There having not been any leave sought, the court therefore cannot proceed to determine on a non-existent, non-compliant appeal that is before you. Why is it necessary that this document get presented? That is the pleadings, the information, and the finding of the court. The reason is for the court to reach out at the point of concern and the heavy duty that has been bestowed upon this court is that a decision that this court is going to make in relation to the submissions that we have made before you will be an authority that is going to be used throughout the Republic of Kenya, especially on opening the window about delays which are unexplained. And this is the reason. There is no any appeal.
You said, and especially, you had said the decision that the court will make in the authority that
Yes, it is a heavy decision that is going to be an authority throughout the Republic of Kenya on matters election petition, on appeals from on MCA position. Why? We will not have a second bite at the Court of Appeal. This is the last court, this is the last port of call. Because appeals end at the High Court under statutes. Now, if that were to happen, the oxygen rule that applies, and especially riding under Article 159(2), will not come to the aid of the appellants. Should not come to the aid of the appellants. Because there will have been a substantial injustice that will be visited upon the applicant. This being the last port of call in matters of election petitions. Now, the other issues, because mine was to put a skeleton of what the case is all about, because everything has been is on record. It is our submission, therefore, that on my submissions as I can, because I can see time is up, is that there is no proper appeal before you. There ought to be equality of all before the law and uniform application of standards of the law to all, irrespective of their status, because this is a time-bound activity. 6 months from the date of presenting the issues, they should be determined. That was an issue to do with costs, but I believe my colleagues are going to address that because the professional time comes in the times. Otherwise, we apply that this application be allowed and the appeal to struggle. I invite my colleague now to take you through some costs and differentiate the authorities.
I'll address you on the issue on authorities supporting our application. My lady, pursuant to Rule 35(6) of the Election Parliamentary and County Petition Rules, yes, pursuant to Rule 35(6) of the Election Parliamentary and County Petition Rules, the record of appeal shall be filed within 21 days from the date of filing the memorandum of appeal. But my lady, there is unison that the purported records of appeal before you were not filed within the stipulated timelines. That the record of appeals filed in this matter were not filed within the stipulated timelines of 21 days. There's no dispute about that. My lady, to support that, the authorities, no reason has been advanced by all the respondents why their records of appeals were filed out of the stipulated timelines. No evidence has been adduced.
Just a minute. Yes.
No evidence has been adduced to support the delay in filing the record of appeals. And my lady, to crown it all, there is no application before you that has been made to extend the filing of the said records of appeal. There is none, no application has been filed. And ready to support our application,
Yes.
I'm going to rely on the Supreme Court decision of Moses Mushigi and 14 others versus the IBC. The same decision appears at number 1 in our list. Sorry, Moses Mushigi
Yes.
versus the IEBC.
Yes.
Finally, the Supreme Court at
Citation?
it's 2016 EKR,
2016?
2016 EKR.
Yes.
We are relying on paragraph 65 all the way to 67 of the same decision. And the Supreme Court, in summary, had this to state: that in many cases, procedure is so closely intertwined with the substance of the case my lady, the Supreme Court went ahead and stated that where a procedural motion bears the very ingredients of just where a procedural motion bears the very ingredients of just determination, and yet it is overlooked by a litigant, the court will not hesitate to declare the attendant pleadings incompetent. And then at paragraph 67, the Supreme Court made reference to Article 159(2)(d) and stated that that article is not a panacea to be deployed by litigants for not complying with express rules. To be deployed by litigants for not following express rules. But appeal before you. We are before you because important documents, that is the record of appeal, that should in determination of an appeal within the stipulated timelines. On matters of election petitions, stipulated timelines, my lady. My lady, this is an appeal on an election petition to be heard and be determined by the court within 6 months. Therefore, time is of essence in these proceedings. In the first appeal, no record has been filed at all. That is appeal number 1 of 2022. In appeal number 1 of 2023, there was a delay of 36 days. Appeal number 1 of 2023, there is a delay of 36 days in filing the record of appeal. In appeal 3 of 2023, there is a delay of 10 days in filing the record of appeal. And I repeat, apart from the court being told to extend the timelines, no reason has been advanced for the said delay. No reason at all. My lady, I further rely on the second authority in our list of authorities, still by the Supreme Court, in the matter of Nicholas Kingston. That is Nicholas Kipto versus the IEBC, 2014, EKLR. Lady, at page 52, the Supreme Court had a comment to make on a document that was filed outside the stipulated timelines. That is the last paragraph at page 52 and page 53.
Paragraph?
Sorry, it's not, the paragraphs are not marked, but this is page 52 and page 53. The last paragraph of page 52 and the first paragraph on page 53. This is what the court had to say. By finding an appeal out of time, before seeking extension of time, and subsequently seeking the courts to extend time, and recognize such an appeal, is tantamount to moving the courts to remedy an illegality. My lady, that means whatever that is before you, that is the alleged records of appeal, are illegal documents. They're illegal documents, not known in law. And the same should be struck out. My lady, those two authorities I've quoted are from the Supreme Court. And this court, by virtue of Article 163(7), is bound by those decisions. I'll quickly distinguish those authorities from the authorities quoted by the first respondent. The first respondent has quoted an authority from Kericho High Court at their paragraph 10. The authority of Lona Chemutai versus the IEBC.
The first respondent.
Yes.
The authority of?
My lady, sorry, the first respondent appellant. In seeking that you extend the time for filing the records of appeal, has quoted the authority of Lona Chemutai versus the IEBC. I believe it's in their list of documents. The IEBC. My lady, I submit that that authority was issued by the High Court and not at all binding to you. The second authority, yes, maybe just 2 minutes. 2 minutes.
Sorry? Yes.
She has donated 2 minutes.
Yes.
The second authority on John Munuve, I believe it is in the list of documents, where the Court of Appeal extended time in filing a notice of appeal outside time. Yes, it was about a notice of appeal filed out of time. I humbly submit that there was an application for extension of time. In this case, no such an application has been filed before you. And my lady, the last authority quoted, that is, there's an authority of Mawathe Julius versus the IEBC. Mawathe Julius versus the IEBC, where the Supreme Court there was a prayer before the Supreme Court to strike out a supplementary record of appeal that had been filed out of time. The said supplementary record of appeal was sustained because the law did not provide timelines for filing that document. Those authorities, my lady, do not aid the application before you, and I have to submit. Thank you.
Miss Wanjoy.
Miss?
Wanjoy. Our last ground relationship is on why these appeals should be struck out is on the issue of dispository of security for posts. Your lordship, all the appeals, the 3 appeals, none has deposited any security for posts. Which is being provided for under section 78(1) of the Elections Act. My lady, under section 78 of the Elections Act, part 2C. Sorry? Under section 78,
Yes.
subsection 2C, a person who presents a petition to challenge an election shall deposit 100,000 shillings in the case of a petition against a member of county assembly. Such is the case before you. My lady, what is the rationale for depositing security for posts? It is to discourage frivolous and vexatious appeals. Vexatious appeals, my lady. It is also intended to compensate a successful litigant. This was supported in the case of Ibrahim Ahmed versus the Ibrahim Ahmed AHMED versus IEBC and 2 others, 2017 EKR. Justice Kimaru, as he was then, stated that the requirement for the deposit for security of cost is a substantive legal requirement and is not a procedural technicality that this court can excuse or extend time to enable compliance to be made. Another case, my lady, is Wilfred Hikayet Kuyo. Wilfred, W-I-L-F-R-E-D. Hikayet, K-I-K-A-E-T. K-A-E-T. Kuyo, K-U-Y-O. Versus Letulal, L-E-T-U-L-A-L. Ole, Masikonde, and two others, 2018 EKR, which was an appeal, same as this, my lady, challenging the election of a member of county assembly. The appellant in that case, Your Lordship, deposited security for costs. Therefore, Your Lordship, in that case, deposited security for costs. On account of failure by the appellant to deposit security for costs, we submit that all the three appeals are incompetent and liable for striking out with costs to the first respondent. Finally, Your Lordship, who should bear costs?
I didn't understand the point you are making.
Yes.
In this case of Wilfred.
Yes.
You just said the appellant deposited. So
Yes,
what is
Your
your point?
Our point is that in that petition, in that appeal, same as in this case, the appellant deposited security for costs. So that and in the final determination, Your Lordship, there was an order for that cost to be given to the respondent.
So now what I'm wondering is, what point are you making? Because I know there's an issue here, and I'll hear from the respondents as to whether the requirement is for substantive petition or whether it is for an appeal.
Both, Your Lordship, in
And that's the point I want you to make.
Yes,
Because
in the-
now when you say that he posited, you
Yes.
have not made a point, you have just stated.
Okay,
I
yes.
want you to convince me
Yes.
that it is a requirement.
Yes.
of appeal. And I
Yes.
think that is a submission you are going to.
Yes,
Isn't it?
yes. It is a requirement in appeals
Yes.
that the appellant should deposit a security for costs.
So now how does this authority support?
It supports our case, Your Lordship, because the appellants, both of them, never deposited any security for costs.
No, I'm not talking about our case.
Yes,
This authority you have,
yes, Your Lordship.
you have said it deposited, you have chosen to do that.
Yes.
But now, I want you now to tell me, how does that authority support your case? I mean, what was confessed in that issue on, regarding the issue of security?
Okay, Your Lordship, Mr. Omwoyo will finally submit on that. Yes, Your Lordship, on our last point is who should bear costs for this proceedings. It is trite law, Your Lordship, that costs follow the event. A party who calls for events by instituting suits and/or appeals will bear the costs if the suit fails. But if the party shows legitimate occasion by successful suit, then the defendant or respondent will bear the costs. My lady, as the successful litigant, the first respondent prays that she be awarded the costs of the application the underlying appeals together with interest thereon. That is all. Thank you.
Yes. So how much time are we going to need for one more for now?
Quick,
Yes.
my lady. My name is Nyamira. In the matter of Wilfred Kikait Kui, my lady, the court order was that the security for costs deposited in this court to be released to the appellant depositor. My lady, the basis is that before the court could order for the release, it was condition precedent that there must be a deposit. Otherwise, courts will not have the money to order to be released. The parties must deposit. And that is why the court has now the power to grant orders, because the court orders cannot be in vain. In this matter, if the court allows this election petition appeals to proceed, in the event that the appellants lose, the court will give orders in vain. There will be no costs. So that is the position in this matter, that once there is an authority that clearly demonstrates that the court went to the reservoir of judiciary, found there are costs there, then it saying the winner takes it. Here there is no money for you, my lady, to grant whoever will lose or whoever will win.
So you're saying in that authority?
That for courts to grant costs as orders, those costs must be deposited before the determination of the election petition. Or the court orders will be in vain. And that is why there's a rule of 100,000. Thank you. My lady, my submissions, you'll grant me 1 more minute out of, I was assisting my good friend.
Mr.
Only
Omwoyo,
one
like
minute.
I pointed that out, this decision, I want each party to convince me
Yes,
on that which was included in
Yes.
the costs.
yes,
Because my reading of the law is just as yours. You
Yes.
know what the law provides.
yes, yes.
And here we have the respondent's case and we have the applicant's case.
Yes,
Yes, so I want you to support your position as much as you can.
yes, yes.
Convince me that the requirement for deposit security in appeals.
Yes.
And at the same time, I want the respondent also to convince me that there is no such requirement.
Very well.
Yes, that is all what I'm looking for, and that is why I'm asking all these questions, because I would want to know the basis for your submission and the basis for your submission. Because at the end of the day, that is where the issue of security of cost lies, isn't it? Yes.
My lady, the basis of our strong position in law is that election petitions
Yes.
demand deposit of those costs
Yes.
by statute.
Yes.
An appeal from a lower court It is an appeal governed by the election rules that demand deposit. If Parliament contemplated non-payment of deposit at appeals, it could have put it expressly that in appeals, phase one is not. So the special rules for an election petition have not been hosted. That is the strong position that we have. The respondents have not provided for any section of the law removing them from paying that deposit. That was to over 100,000. And then the second limb is that the second limb of my submission is that what is the import of the judgment that you are going to give? My lady, I submit that this is not a matter between two people, the applicant and the respondent. This is a matter about 520,000 people of Nyamira County.
You said how many people? 500
20,000 people of Nyamira County. Who will be their representative at the county assembly? Who will pass laws for 5 years on behalf of those hundreds of thousands of people? Number two, Your Honor, to show how grave this matter is, this is a position that comes after the will of the people has been done. That is when IEBC picks from the party list who to be nominated. Jubilee Party got the will, the general will of the people, and was allocated a slot. That is the third respondent. After elections, and they got the general will of the people of Nyamira County, they were allocated a slot. They are here as third respondent saying to them, the person or their person is the first response. They are disowning the appellate. That is the general will of the Nyamira voters represented by Jubilee Party. Third, my lady, the other angle, is that the seat being sought is going to be of a legislator.
What?
Whoever the contest is about an MCA position. The Nyamira people expect the victor from this case to be one who shall be compliant.
You know?
To be one who shall be compliant with the rules and regulations that she will be passing in the assembly for 5 years. My good three councils who are presented have shown you complete non-compliance with the statutory provisions by the first respondent. Lady, the question of compliance with the statutory timelines of filing pleadings has only one remedy.
Yes?
Only one remedy if you want to not to comply with the timeline set. Has only one remedy, my lady, that is to seek leave from the court failure to that then that party has arrogated to itself judicial power. That party should be punished. We are before you, my lady, as I submit finally. The first respondent decided to be the court itself and failed to seek leave. Therefore, the three appeals are moot. But kindly don't give the Nyamira people an appellant who has completely refused to comply with the statutory requirements. This decision has a serious impact to the Nyamira people. As I said, it's not about two ladies fighting, it's about the general will, the Nyamira people. Lastly, my lady, on the last link of costs, I'll donate my 2 minutes remaining to Nyaberi to re-emphasize so that once the other team responds, we do not go for rebound to reject. Mr. Nyaberi, only 2 minutes, I think. Only 2 minutes. Yeah, only 2 minutes.
Melody, on the issue of costs, is that section 78 of the election county.
The issue of cost or security?
The security for costs. Security for costs. Security for costs. Under section 78, under which we have moved the court, is attract, or the statute says that a petitioner who moves the court must deposit 100,000 in case of an MCA position into court. That law is silent on appeals. But the appeals get live from the decision of the lower court.
So now what is the submission I wanted to hear from you? So can you now submit that for you?
Yes.
Yes.
The appeals get their life from a decision that has been made by the lower court.
Okay, you started by saying that section is silent.
It's silent on deposit of security for costs in the appeal. But in the court that tries an election petition at the first instance, it is a requirement that a petitioner must deposit a sum of 100,000 in the case of MCA position to the elections court in the magistracy court.
Yes.
Now, it being an appeal emanating from a decision or a petition that has been filed in the magistracy court, maybe that line is transposed into the High Court, being the appellate court.
You said that like this.
Is transposed, it's brought up to the appellate court, being the High Court, that security for costs is supposed to align to an appeal that has been lodged. So in the instant case, is this court inferior to a magistrate court which has received a sum of 100,000 shillings as security for costs? The answer is no. That security ought to be deposited also in this court at the very minimum. In fact, we have other instances where security for costs for an appeal has been, a deposit of 500,000 shillings has been given. But since the law is silent, at least let there be a deposit of costs by the appellant into the High Court challenging an election petition. Why? It is a petition, but on appeal. It is an election petition which is founded on appeal. And therefore, it is not available to the respondents in this application to state that they waited for the judiciary to generate a receipt for them. That if given an opportunity, they will go and pay. They know they are supposed to pay by that very environment. They knew all along that they were supposed to have paid, but they sat on their laurels. The law assists the vigilant and not indolent litigants as the respondents. So therefore, in a nutshell, we are saying the appeals have not satisfied the integral ingredients for them to have a platform of coming before you for any canvassing or any other issue that is present. That is the point of it. Thank you. We are done with the submissions by all of us.
Yes.
Maybe now the Jubilee Party.
Yes. Yes.
My name is the very kind Commissioner of the Brave. My name is Omwoyo. The third respondent in all three petitions. At the very outset, I wish to make a very clear indication to court that I associate myself to submissions that have been made by counsels for the first respondent applicant in the application dated the 14th of March 2023. Further to that, my lady, I wish to submit that when you went before your sister, Lady Justice Okwani, this court was addressed about a consolidation that was done before her. Later on, when my colleagues from the other rise up to address you, they will tell you that appeal number 1 of 2022.
Appeal number?
1 of 2022 gets live from the records of appeal filed in appeals number 2 and 3. Appeals number 1 and 2 of 2023, my lady. Sorry, my lady, 1 and 3 of 2023.
Right from appeals E001 of 2023
and E03 of 2023, my lady. My lady, for reasons that I don't have time to probably respond to them, I wanted to go on record that in 3 appeals, and why, as the Jubilee Party of third respondent, we didn't oppose consolidation, was that we wanted one ruling that dismisses all the 3 incompetent appeals before you, such that you should not be told that appeal number 1 of 2022, by virtue of the consolidation, it becomes it has a record of appeal. It doesn't have a record of appeal. As I move on, my lady, you were also told about the importance of the decision of this court in this matter. My lady, you were told about the importance of the decision of this court in this matter. And to buttress that further, my lady, in the circumstances, we have records of appeal filed out of time. My lady, over and above the people of Nyamira and all that you've been addressed, that stuff, my lady, I pity the academia or our students at law school who will be reading precedents, because these are precedents in terms of appeals in the context of a member of the county assembly, my lady. I urge the court not to give room to our young ones in law schools to get to have the courage that you can file documents out of time without leave and you are entertained. My lady, as I move further, I'll quickly move to the question of posts or security for posts. I'll begin by submitting that the question of costs is an record put down in paper at section 78 of the Elections Act. And the same is in respect to petitions. In further developing my colleagues' submissions, I wish to invite court to Section 2 of the Elections Act, which gives the term petition a definition. And the same Section 2 of the Elections Act, a petition is an application to the Elections Court under the Constitution and under this Act.
It's an application?
It's an application to the Elections Court under the Constitution and or under this Act. This is an election court which was specifically gazetted to deal with this matter. Secondly, already, by dint of the finding of the trial court, that is the magistrate's court, by dint of the decision of the magistrate's court, the first respondent is the member of county assembly. The first respondent, who is the applicant here in Malidi, is the member of the county assembly. The effect of that judgment is that she is the member of the county assembly through nomination by the third respondent. That will stand until such a time the same is disturbed. Therefore, my lady, at this appellate stage, the appellant is applying to court by way of a petition, is moving court, is applying, is making an application contemplated under section 2 to this court by way of a petition seeking notification of the decision that found our nominee, the applicant herein, to be the validly elected member of county assembly by nomination. As such, my lady, section 78 of the Election Act on post is applicable. On security for post, my lady. Yes, I'll return that. Thank you. And I adopt my submissions.
Yes, we can now draft the correspondence.
My name is Ochoki. For the appellant first respondent, the application, my lady, is opposed. There is a replying affidavit sworn by the first respondent on 27th of March 2013 and filed on 28th of March 2013, my lady. 28th of March 2023. Sworn on 27th of March 2023 and filed in court on 28th of March 2023 in opposition to the application. We've also filed, my lady, our submissions on the 12th day of April 2023. I will be relying entirely on those submissions, my lady. And allow me, my lady, humbly submit that when we took directions before your learned sister on 28th of February 2023, there was an agreement that the appeals be consolidated. And as we are here before you, my lady, the appeal is one. Further, my lady, all applications that were pending as at the 28th of February 2023 were abandoned, and there was an agreement that the substantive appeal be heard. My colleagues, however, have filed this application, which is before you this morning, and have sought to separate the appeals. My lady will notice that appeal number 1 of 2022 that appeal number 1 of 2022 arises out of a preliminary objection that was disallowed and no stay was granted by this court in an application that was filed. That position, my lady, has been explained by the first respondent in her affidavit. The question that arises, my lady, for determination is whether the record of appeal was filed on time. And the first respondent admits that that record of appeal was filed out of time. Leading to the question, my lady, is filing the appeal, record of appeal out of time, fatal? In our humble submission, my lady, it is not fatal and does not make the appeal incompetent. My lady, it's a trite law, as I address that issue, that parties are bound by their pleadings. And my lady, in the application dated 14th of March 2023, my colleagues, even after the consolidation, have endeavored to split the prayers into the various appeals. But curiously, in respect of appeal number 1 of 2023, they have only, their appeal number 1 of 2023, they have sought in prayer B to strike out the supplementary record of appeal filed on 7th March 2023. Filed on 7th of March 2023, and the memorandum of appeal dated 11th January 2023.
Memorandum of appeal dated
11th of January 2023. My lady, on record, the first respondent filed 2 supplementary record of appeals on 7th, both dated 7th of March 2020. Two record of appeals. She also filed
both dated
7th of March 2023. She also filed a record of appeal. I believe it's on record, my lady. Dated the same day, 7th of March 2023. 7th March 2023. My lady, there is no prayer seeking to strike out this record of appeal and one of the supplementary record of appeals. So that
we're saying on record, the first respondent filed 2 records of appeal.
2 supplementary records of appeal and a record of appeal. 2, my lord, apologies. 2 supplementary records of appeal and a record of appeal, my lady.
And the supplementary are dated 7th of March.
Yeah, all of them are dated 7th of March, my lady. So that my colleagues are only seeking to strike out one of the supplementary records of appeal. So that even if you are to strike that one supplementary record of appeal, then the record of appeal And one of the supplementary records of appeal will remain. So that their prayers, if you are to grant the prayers as sought, will still leave a record of appeal on record. And I'm sure, my lady, that was not the intention.
Can you please submit on that?
Pardon?
You submit another way?
My lady, I was submitting that in their prayers, in my colleagues' prayers, prayer B, they have sought to strike out a supplementary record of appeal. Yes. But on record, my lady, are two supplementary records of appeal and a record of appeal. Yes. So that they have not prayed for the striking out of one of the supplementary records of appeal and a record of appeal. So that you cannot grant that, my lady, what has not been prayed for. So that it's our humble submission that this is an application that you cannot grant, my lady. My lady, my colleagues referred you to two Supreme Court decisions with regard to timelines. That is Moses Muhimu and the other one. But I wish to humbly submit, my lady, that what we are seeking is an exercise in this of your discretion. The orders that we are seeking are discretionary. Your discretionary orders cannot to be bound by a Supreme Court decision when you are exercising your discretion. I hope it came out clear.
No.
Yes. We are saying, Your Honor, my lady, let me refer you, my lady, to Rule 19, as I submit on that point. Rule 19 of Election Petition Rules 2017, which provides, my lady, I'm referring you to Rule 19 of Election Petition Rules 2017,
Rule 19
of the Election Petition Rules 2017, which, my lady, provides that where an act or omission is to be done within such a time as is prescribed in the rules,
where? And that?
or omission is to be done within such a time as is prescribed in these rules, the election court may, for purposes of ensuring that injustice is not done, extend or limit time. Extend or limit time within which the act or omission shall be done. So, my lady, our understanding of Rule 19 is that extension of time is an exercise of discretion based on the circumstances. So that reference, my lady, to decisions of the Supreme Court for entirely different circumstances. That is why my lady, and we have annexed positions that I do not want to go to because you'll have an opportunity to look at them. Your colleague sitting in Kericho, that is Lady Justice Mumbi Ngugi, I believe now she's in the Court of Appeal, my lady, did agree in her decision, my lady, in election appeal number 1 of 2018 at Kericho. In election petition appeal number 1 of 2018 at Kericho, where she said, my lady, that filing a record of appeal is not fatal as courts have discretion to extend time, which she exercised in that matter.
Filing of a record of appeal?
Late
Yes.
is not fatal,
Yes.
and that the court has discretion in the interest of justice to extend time. You have that discretion, my lady, to extend time. That, my lady,
Just a minute. What was that movie dealing with? That,
it was a matter, my lady, where a record of appeal, similar to this one, had been filed 5 days late. And there was an application seeking to strike out that notice of appeal. Yes. Yes.
It was dealing with an application to strike out, not an application to extend time.
No. My colleague, I believe, was misleading you when she indicated that it was an application to extend time.
It was an application to strike out.
Pardon, my lady?
So that movie dealt with an application to strike out.
It's a judgment, my lady. She was dealing with these issues. Just a minute. Let me be clear. It was a preliminary objection, apologies, my lady,
Yes.
that the appeal is incompetent, valid law and improperly before court, that it was filed out of time and there was no deposit of security. Similar issues that we're dealing with. Yes.
Yes.
Yes, so that she did find that it is an exercise in discretion. Discretionary to allow such an application. My lady, if you allow me, because my time is running, I'm not going to issue 2. That was also the...
Yes, what I wanted to come out clearly.
Yes.
What is on.
Yes.
Should this discretion be exercised by the court when the court has not been moved to extend the time?
My lady, yes. Actually, the reason why I have not addressed you on the court not being moved is that my colleagues will admit, when we were before Lady Justice Okwanyi on 28th of February, I did mention for a period of 7 days. But your learned sister, for some reason, decided to grant general leave without necessarily giving directions as to the filings of the appeal. You do, where reasonable explanation has been given, and my lady, in the replying affidavit,
Yes.
which answers what is in the application, the first respondent has explained what happened, especially with regard to the first appeal. That matter, she's explained, was pending in the lower court. No judge had been allocated this file until you allocated this file recently. So that it was not possible, considering that proceedings, there was no stay granted, and the matter was proceeding in the lower court. So that it was not possible, there was no judge, she sought stay, nothing was happening, my lady. So that even without you being moved, in the interest of time, having the record of appeal being on record can be deemed as duly filed, my lady. That is my take and understanding.
Yes. Let us then proceed.
Yes, my lady, that was the case. What you just asked me, my lady, was determined by the Court of Appeal sitting in
Because
Nairobi.
that issue has been raised by the applicants and you have had it several.
Yes, yes. Let me go there, my lady.
For extension of time.
Let me go
It's
there.
important that you address it appropriately with the.
Let me go there, my lady.
Yes.
The one that has addressed that, two of them, you look at my lady John Munube Mati.
Yes.
John Munube Mati is a Court of Appeal decision in Nairobi. We've annexed it, my lady, to our submissions. It's election appeal number 5
Yes.
of 2018.
Petition number?
Election petition number 5
Yes.
of 2018.
Practice?
The parties are John Munube Mati versus as appellant versus the returning officer, Mwingi North constituency, and 2 others. Where the Court of Appeal, my lady,
Yes.
did find that though the appellant did not file and serve the notice of appeal within the prescribed time, the court itself said that decisions of this court are bound, where it had indicated that the prescribed timelines in electoral disputes must be adhered to. Nevertheless, the 2017 rules, that is the court, my lady, now expressly confer on us, on the court, discretion to determine the effect of any failure to comply with the rules, taking into effect that justice must be administered without undue regard to procedural technicalities. It allowed that. But specifically, I have a decision, my lady, which where there was no formal application made, and that decision, my lady, is a Supreme Court decision actually. Apologies. It's in my list of authorities, my lady.
Just give me the situation.
Okay. It's a petition number 16 of 2018 in the Supreme Court, my lady. Mawade Julius versus IBC. My lady, in that matter, at paragraph 51, the Supreme Court did find, at page 51 of that decision, did find that though the appellant had not sought leave to file the documents out of time, the court was of the view that this procedural infraction occasioned no injustice or prejudice to any party. As such, the Supreme Court says it was unable to justice at the altar of strict adherence to provisions of procedural law.
Sorry?
In the matter, the Supreme Court did find that though there was no compliance with the timelines, the court was of the view that there was no injustice or prejudice occasioned to any party, and therefore it was unable to sacrifice justice at the altar of strict adherence to provisions of procedural law. So that the court, my lady, did find that it could not sacrifice justice over the provisions of procedural law. And in this one, my lady, you get a look at it, there was no application similar to this one. My lady, finally on that point, the applicant has not shown the court what prejudice they will suffer. And my colleagues extensively talked of the people of Nyamira. What prejudice the people of Nyamira will suffer, or the applicant will suffer, if you allow the documents on record as requested also. Or exercise your discretion in favor of the appellants. My lady, we humbly submit on this point that you can extend time for compliance in the interest of justice, because the applicant will suffer no prejudice whatsoever if you allow these orders, if you allow that the matter proceeds and is heard on merit. My lady, you were, allow me to address you on the issue of security for costs. My lady, Section 78 of the Elections Act, which my colleagues have extensively referred you to, at Section 78(1), it starts with a petitioner shall deposit security for payment of costs. At 78(2), it talks of a person who presents a petition. My lady, there is no mention whatsoever at Section 78 of the Elections Act of an appeal. And my colleagues, the battery, all of them, were not able to get one decision, my lady, one, in which an appeal was struck out for failure to comply with the provisions of Section 78 of the Elections Act. My lady, in her replying affidavit, the first respondent has told the court that nowadays, and the court and my colleagues must be well aware, that matters, judiciary fees, are system generated. My lady, you cannot make payment of any fees without an invoice being generated, including for security of costs. And the judiciary e-filing system has not come up with an invoice for security for costs. Be that as it may, my lady,
You're saying the judiciary has not come up with
a system of generating invoices.
how did the other who are paying the bill of cost?
My lady, those are security for costs for petitioners, initial petitions, petitions that
Also,
are
you are saying
filed
in the appeals.
for appeals. For appeals,
But there are some cases where people pay. How do they pay?
I'm
Whether
not
it's a
aware.
legal requirement or not, that is neither here nor there.
Yes.
But how do they think?
In this case, no invoice was generated. I'm not aware of any or that has been paid. For these other things, for like replying affidavit, my lady, the minute we download, there is an invoice that will automatically come in the portal so that we are able to know that this is the invoice, they send the code so that we are able to pay.
Did you follow it up? We have a solution for everything cancelled. So even though it is not provided for in our CPS or
Yes.
our system,
Yes.
you are not going to shut out because it is not provided for.
My lady,
So convince
possibly.
me that the reason is not information.
No. That I was just starting, my lady. I'm now convincing you, and I refer you
Yes.
to the decision by your learned sister, Lady Justice Mumbi Ngu, in Lona Chemutai, the matter, the initial decision that we were referring to you to.
Which
But
is
the first one that I referred you to,
It's the same
where,
one.
yes, the same one, my lady.
yes.
I hope you got that so that when you sit and as the bar will raise it
Yes.
on possibly how invoices, even in the bar bench, will raise it on issue
No, it
of.
is because I have been the judiciary and some of them are not provided for. But a council will not be shut away. I mean, it will not be sent away because it is not in the system. Because the system keeps changing.
My lady,
we will
off
always
record.
provide
Off,
for some of these things that are not.
off record, there's another matter I'm handling where I've done a letter to the DR and is not actually been able to act on it. Yes, where I've sought to pay security for costs. But that is off record.
Have we
This one-
escalated it to the head of
This
the
one
station
we
and
have
the
not.
judge?
Pardon?
Have we escalated it further to further the head
Possibly.
of the station and the
Maybe
judge?
protocol demands that we start with the DR and possibly the bar bench we can address it with the presiding judge. We have
What
not.
use is it to overemphasize on protocol when your client is suffering? I mean,
The line comes from this area to depict the judiciary as having a problem for this public. The media can capture that. It's a serious line.
and
Yeah, that's what I'm saying.
judiciary. And that is why I
He should
cannot
be
let
very
that-
careful. He should be very careful because the other place he said he wrote a letter. Here there is no letter or a confirmation from judiciary that we are unable to receive the money. Kindly let us not demonize an institution
Yes, and-
that has really struggled to be where it is.
And there is no way I'm going to let it pass.
That's what I'm saying.
Because
I'm
I'm in the
on some-
judiciary and we do the best to ensure that you get services. If a council walks into our chambers and tells us the system is not working, you tell you, can you go and pay manually? Let us sort it out later. I would rather that the judge or our court administrator sort us an affidavit. But don't blame the judiciary where there is no.
I wasn't blaming my lady. I think
Yes.
possibly, and apologies if I blame the judiciary, it wasn't my intention.
Yes.
My intention was just to bring it out that there was no invoice, there has been no invoice generated. And my colleagues can access
Yes.
the portal and confirm whether there is any deposit, any demand that has been met, because it's all indicated there. There has been none for 100,000, which is the security for deposit. So I was, possibly it came out wrongly, but I cannot at all, my lady. I earn my daily bread by presenting my clients in court, and I will be the last person to blame the judiciary. So that I was just saying, my lady, that no invoice has
Yes,
been generated. But we will possibly just follow it up. And if my lady is to make an order
Yes.
that the deposit be met,
Yes.
even out of time, my client will gladly make the payment, my lady. But lady, perhaps my saying my time is up. I will beg that.
No, I'll give you 1 or 2 minutes because I've engaged you on an issue that you may not have been prepared for. So I'll give you an additional 2 minutes.
The 3, my lady. because there are 3 decisions here that where your colleagues, yourself, not your colleagues have rendered themselves on the issue of security for costs on appeal.
Yes.
Yes, my lady, in the Lona Chemtai matter that I'd mentioned initially,
And I'm hoping these cases
we
filed.
filed.
Started by ensuring that
They-
all the submissions are.
Yes, my lady, yes,
Okay. So we are
yes.
there on the case of?
Lona Chemutai that we cited initially,
Yes.
the Lady Justice Mumbi Ruby, my lady, did say that there is no provision, no express provision of law requiring security for costs with respect to election petition.
Petitions?
Election appeal, sorry.
Appeals.
Yes.
Yes.
And she did proceed to say, I believe it's in the discretion of the court to balance the competing rights of the parties, and did ultimately, my lady, make a finding ultimately that the appellants were to deposit an amount as security for costs. Ultimately, she did say so, but if you look at the decision, my lady, she's saying that there is no provision, so that it's not fatal for parties when they comply. Yes.
She left a room.
Yes, yes, she did. But my lady, if you were to look at the 2 other decisions, and I will just beg that you allow me just for purposes of record, mention them to you, because the High Court sitting at Homa Bay has rendered itself, that is in election petition, appeal number 5 of 2018.
Appeal number 5?
Appeal number 5 of 2018, my lady. The parties are Odongo Victor and IBC and others. Justice Karanja, my lady. Did make a finding later upon parties. There was an application made to strike out an appeal. Your learned brother, my lady, did make a finding that Section 78 of the Elections Act provides for deposit in respect of election petitions, but not appeals. Yes. Finally, my lady, because of time, allow me just refer you to my last decision from the Court of Appeal sitting in Nairobi. That is civil appeal number 287 of 2013.
Yes.
Lydia Mathia versus Lydia Mathia versus Naisula Lesuda and others. My Lord, the Court of Appeal in that decision, and we've highlighted the relevant parts, did provide or did indicate in the decision that it may be well that Parliament deliberately avoided legislating on deposit for security for costs in appeals, since an election petition is quite distinct from an appeal. And the court did, my lady, indicate that an appeal confines itself to matters of law, while election petition involves factual evidence. So that the Court of Appeal, my lady, did indicate that Parliament could have been clear in its wisdom if it indeed had required that there be security for costs. My lady, we are humbly submitting that the first respondent is ready and willing to comply with that provision, should you make a finding that there has been non-compliance. But it's our humble submission that the section 78 does not refer to appeals. My lady, finally, Ms. Lisa Wairimu did address you on costs.
Yes, before we reach that point of security of cost, we have seen other judgments by judges.
Yes, my lady. Yes.
As to the rationale
Yes.
of security of cost. And section 78 notwithstanding.
Yes.
What is your take on that?
My lady, ordinarily, this is just because costs petitions used to be filed by political candidates using proxies who had no means whatsoever. That is the rationale for section 78. But ordinarily, a successful litigant can execute, especially, my lady, where a party, in this case, the respondent is assisting member of county assembly. That cannot be said to be a pauper from whom costs cannot be recovered. What used to happen, my lady, is people could pick any person from the street and file appeals through them. So that section 78...
Any person from the street and file appeals?
Not the politicians. I can stand against my learned brother, Dunstan, but I will not file an appeal against him. I will get someone, a voter, who has nothing to file an appeal against him. That was the rationale for the section 78, so that these people ultimately, successful litigants, could never recover anything from them. Yes.
But the rationale applies across the board.
It does.
Whether somebody else who is filing an appeal, hiding under somebody, or whether it is the actual person.
It does. It does. It does.
So now, how does that rationale sit on petitions? Is it the same thing?
Looking at it, it's basically the same argument to agree with you, my lady. Yes.
So you are agreeing that it is important for a party,
so that possibly it's not clear, because my lady will follow the law, and that is why my colleagues have relied on section 78 to argue or to urge you to allow the application. But the same section 78, my lady, is silent. So that when it's silent, you know, the law ordinarily needs to be expressed, just like it does for petitioners, and says petition. Ordinarily, there are sections that deals with appeals, but and in the decision from the Court of Appeal, the court has exhaustively tried to think behind why Parliament was not expressed in providing for security for costs on appeal. Yes, because I think in their wisdom, or lack of it, I think they never thought that a situation could arise where such applications are going to come before you, and they are putting you in a very difficult situation, because they could have easily said for appeals, and actually now, considering it's the High Court, could have been higher than the 100,000 that is deposited in the magistrate's court. Yes. So that
yes.
I hope my lady.
Yes, it is because it is a real issue with this appeal. That is why I want to catch the thoughts on it. Just like I heard from the other party.
My lady, our tech.
So that you help us.
My lady, our tech is, as you retire to make your decision, our tech is that now that section 78 is silent on appeals, yes, then the court's hands are tied. You cannot, because section 78, my lady, if you are to look at A, it talks of, it's clear, it talks of a petition. It doesn't mention an appellant.
Actually, it talks of a petition.
Yes, so that if it could have said petitioner, stroke appellant, and or appellant, then it could have been easier, my lady, for even compliance. So that our take is, now that it mentions a petitioner, and actually it talks of, if you look at 2, my lady, it talks of a person who presents a petition to challenge an election. It talks of challenging an election shall deposit. So it doesn't talk of, appeal, second appeal, which could have come down possibly to.
What does an appeal tell him?
It's an election.
What is the decision of the High Court when it is in an appeal? They can settle the judgment.
It can.
So, from that argument,
Yes.
then why would we say that Section 78 also applies to appeals?
Why? We can. Actually, my lady, if you look at the decision by Justice Karanja,
Yes.
Subsequently, he said that he's interpreted Section 78 ultimately to include appeals and has given time for compliance. Yes.
Yes, because under
It's
the
only that
yes.
no appeal
Yes.
has ever been struck out for non-compliance.
No, we are not saying we are striking out or we are not. We just want to see. I just want to benefit from the arguments, right?
Yes, my lady.
Yeah, which is very important because.
So possibly, my lady,
Yes.
if I was to sit in your position, I will possibly propose in my decision that Parliament enacts. My lady, we are sharing off record.
I think too far. I think we'll give them the time.
No, I want to get his thoughts because just like I wanted you to address me on that. Why there's whether the provisions of Section 78 regarding security of portion of private provisions. Because we all know it talks about petitions, does not talk about appeals. So for purposes of purposeful reading of the law and the interpretation and all that, that is why I wanted to hear his thoughts. And yes, you are done?
Yes, my lady, I was just indicating that ordinarily, possibly what the judiciary needs to do is propose to Parliament to enact clear legislation.
You have proposed petition and all and they have not voted. So
yes,
we can only do what we have to. Even very, even matters that warrant intervention. So let us just deal with what we have.
On
the moment.
My lady, on the last.
When you ask for this legislation, tell them when they go to buy it. You should remember when they don't buy it. The laws are not for the judges. They are for people.
True.
Yes, so when we give recommendations, a statute is declared unconstitutional, we tell them to give us a way forward, they don't give us a way forward. So sometimes we have a lot of problems.
My lady, on the last point, did address you on the issue of costs.
Yes.
And I am fully in support of her submissions that costs ordinarily follow the event. Yes, and on that one, I'm in agreement with her that I will be adapting her submissions on the issue of costs. And my lady, at your position on the issue, this is something that we don't really need to address you on.
Yes, that one we don't need
Yes.
to address
Thank
you on that.
you, my lady. Thank you.
Now, that was first response. Yes, second respondent, we are working with them.
ventilate our appeal which is on record. Maybe we stand by it. That's all for the second respondent. That's all for the second respondent. We fully adopted the bylaw, adopted submissions.
Yes.
Yes.
The third, yeah, yes. So now you enjoy them?
Yes,
Yeah, 15 minutes.
already allow me to first point out that even after they have made their submissions, the respondents, they have not sought leave to extend time for their record of appeal to be considered as appropriately filed. Come on, Melody.
No, Councillor,
If you allow me to
Approving the
interject,
submission.
I'm done.
Yes.
I was just indicating that it's unfortunate that there's been change of yourselves, because I think I'd addressed that before Lady Justice Okwani. I'm not sure whether it went on record, but my colleagues can confirm that I did address that. So when he's saying I didn't seek that extension, I believe that.
May we protect the good judge who is not here? Because imputing that she never put it on record is putting her to question. And that one, we are very protective of the judiciary. What is on record is what is on record.
yes, you see the code is approved.
That's what I'm saying. That's what I'm saying.
Yes, so anything that was put on record, it was never said. I don't know whether the judge put it on record, but I will be strictly bound
The reason my lady understood is because my colleague is saying that we have not sought for time, and I was saying that initially my lady Yolanda colleague had indicated that we proceed on the substantive appeal, and I'm not sure whether it's right for my colleague to start addressing new issues that I may need to respond to later, because that issue is a new one that has not arisen in our submissions.
Is it a new issue? I thought that had been the issue from the beginning. That is until the substructure, this application. So it is not a new issue.
I believe, my lady, when he's saying we have not sought, I believe I addressed you on it, and that those are misleading submissions.
And if you address the court, I put it on that one.
That's fine,
So
that's fine.
The record you.
Thank you, my lady. Thank you.
Yes.
Melody, as I was saying,
Yes.
the respondents, except for the Jubilee Party, have not sought for extension of time
Yes.
for the issues that are presented in this application to be taken as properly being done. The second issue that I wish to bring to the attention of the court is that even when we go to the proceedings of the 28th of February this year, Justice Omwoyo was of the 28th of February this year, which the respondents are alluding to. And therefore, once this court, this particular court yourself, was gazetted as an elections court, that is when you took the driver's seat on this appeal. Therefore, we do not have a record of appeal. Below as admitted. The application before you is one dated 14th of March 2023. The record of appeal that has been alluded to as having been filed was served on us on the 28th of March 2023. 14 days after this application had been filed.
You're saying it was served on?
On the 28th of March 2023.
Yes.
That is a period of 14 days after the filing of our application. And what had been served was the supplementary record, which then which raised our antennas to file an application for it to be struck out. Supplementary record.
Sorry?
The supplementary record is the one that was served, and that is why we specifically went and got bound by the supplementary record, which we sought, or we are seeking that it gets it was filed out of time and it does not form part of the proceedings before you. Now, a submission has been made about the engagements that we had on the 28th of February 2023. The agreement to consolidate was not a consent. A consent. We did not record a consent in court.
But there's a note of consolidation.
There is a note of consolidation. It is not a consent. There is an order that those three appeals be had by one judicial officer so that we don't have decisions that are cross purpose.
Yes.
But that is not a consent by itself, it is an administrative issue
Yes.
where each of the appeals had a life of its own, and the only reason why they have to be consolidated is for purposes of having a decision that is not at cross purpose. There is no remedy through authorities that has been presented. There is no remedy at law that is known to aid the respondents in their heavy submissions, and the consolidation of the appeals does not remedy the non-filing of the record of appeal as it stands. In fact, the respondents have admitted that they did not file the record. Both of them, they have admitted to that aspect, that they filed the record out of time. And the guiding principle in matters petitions of election appeals is Rule 35, sub Rule 6, which they have blatantly abused.
No?
Rule 35, sub Rule 6 of the election petitions county rules, parliamentary and county petition rules. Milady, an issue was raised in terms of you exercising and insulating yourself with discretion, judicial discretion. That discretion must be judiciously exercised. And that is not to say that this honorable court can overrule a decision of the Supreme Court which they have not answered to the contrary. And even if this court was to exercise that discretion, there is no application that has been presented before you, even at the close of their submissions, that you be invited to exercise discretion in their favor for the record of appeal to be deemed as properly filed. And further, the discretion is not to be exercised retrospectively, meaning if they did not put their house in order before, they cannot now ask that the non-action before the filing of this application to be construed to mean that they have complied. This submission is in line to, we are dealing with striking out of the three appeals, not arguing to extend time. to allow them to do certain things that they have not complied with. And the decisions, as highlighted by my colleague, Ms. Mai, on the court of the Supreme Court, cannot just be watered down by the courts, that is the Court of Appeal and the Superior Court's decisions, because they are binding. They're binding, and nothing of, to the contrary, has been presented before you why those decisions of the Supreme Court should be washed down. We are creating jurisprudence. This court is creating jurisprudence, and the strict adherence to the procedural enactments of law should be followed. Should be followed, because after this, record will speak for themselves, and this is a jurisprudential issue that the court should not then create a gap, because if that is to happen, then we will not have any recourse for appeal, which they have. They don't really appreciate. Now, there was an issue in relation to the prejudice that we will suffer. The prejudice is, this is an issue of people's representation. And the Jubilee Party, who nominate the person to occupy that seat, have said that the applicant here is the rightful person. So the prejudice that will be suffered if the court does not nip this at the bud is that there is going to proceed the hearing of appeals which are not grounded at law by people is not going to be there, because the applicant shall have been denied unduly to hold office for this period that will be waiting for the appeal to conclude, which appeal is not having any legs to stand on. As submitted in relation to Section 78 of the Elections Act, the two authorities that the respondents have cited on, that is the authority of Lona Chenpai case by Judge Mudi and the Odongo Victor case by Judge Karanja. Indeed, the holding there was that they aligned themselves to payment of costs.
So which authorities?
The Mudi authority, Lona Chenpai case, and Justice Karanja authority, that is the Odongo Victor case. Both of them were in agreement that security for costs, even when the statute is silent on its payment, appeals filed from the election petitions of MCA position attract payment of deposit of security for costs. And this is even supported by the respondents. So it is something that they are ignored, and we are vigilant. We are vigilant. We have come to court to say, raise the red flag. We say they did not do or comply with the law, and we kindly ask the court to find that even when it balances the competing interests of the parties hearing, there ought to have been a deposit of security for costs, even when the CTS portal or the e-filing portal does not, the judicial e-filing portal does not allow for that, does not have an item listed for filing of security for costs. Yes, the final point I want to submit on is what is if the appeals go on If the appeals go on, what will be the gross effect? It will be fatal.
Council, will you please allow me to make my call?
Most of it.
Just a few minutes.
Thank you.
All the issues.